We would like to introduce our presenter today. Chris Phelps is the training manager for the Rocky Mountain ADA Center. That is a project of Meeting the Challenge Incorporated, the company he works for, and they receive a grant to provide this type of training. Chris has over 10 years of experience creating, preparing, and presenting ADA materials for Meeting the Challenge. He's skilled in all aspects of career development, facilitating, team building, knowledge translation, coaching, mentoring, and focusing training solutions. He's accomplished in preparation of clear, concise, and well-organized written and verbal communications directly targeted for adult learning. And he's coming to us today live from Colorado Springs. And so we appreciate Chris being here and presenting for us on this important subject. So I'm going to go ahead, Chris, you should see a bubble come up. And are you seeing that?
I think so.
Let me try.
All right.
Okay, I've got your screen. So.
All right, fantastic.
Thanks, Chris. Go anytime you're ready.
Good morning, everybody. Just real quickly, we'll kind of dive into this very quick because bottom line is we have a lot to cover and a very, very short time frame to do it. When they first said, hey, Chris, you want to do a webinar? I said, fantastic. They said, you want to cover Title II in 40 minutes? And I said, really? So we're going to drink from the fire hose. And Title II of the Americans with Disabilities Act is specifically focused for state and local governments. Before we get into that too much, though, I will tell you just real quickly, we do provide guidance. We do not provide legal advice. But the ADA centers across the nation, and there are 10 of them across the nation, are available for a whole host of information. So if you've got questions on the Americans with Disabilities Act, give us a call, 1-800-949-4232. I will tell you that wherever you're at, it will route you to the nearest ADA center. I know that because one time I was traveling down in St. George, Utah, actually, and it routed me to the Pacific Center when I was trying to reach my own center. But again, you can call that. It's where it's all free technical assistance, referrals, research training, you name it. We are here to help you. All right. So when we look at the Americans with Disabilities Act, the first thing we want to really look at is who is protected. And this is kind of an overview of the ADA as a whole, but not specifically Title II, but the ADA protects the rights of people who have a physical or mental impairment that substantially limits their ability to perform one or more life activity, major life activity. So when we think about what are life activities, just real quick examples would be things like breathing, walking, reading, thinking, seeing, hearing, working. Again, just some examples, not an exhaustive list. The ADA does not apply to people whose impairments are unsubstantial. So when we look at unsubstantial impairments, just a couple examples would be, I'm nearsighted. I am not covered under the ADA. Or something, say, a mild, keyword being mild, allergy to pollen. Okay. The ADA does apply to disabilities that can be mitigated, and that's an important point. So just because somebody can control their diabetes with diet or medication doesn't mean that they are excluded from the ADA. Somebody who wears braces on their legs to help them walk, even though they can walk, they're still covered under the ADA. The ADA applies to people who have a record of substantial impairments and those regarded as having such an impairment. So my wife had breast cancer. Thankfully, she has beaten it, but she will always have some follow-up based on the cancer that she did have and does have some protection under the ADA. So who has responsibilities under the ADA? Well, specifically, because we're talking about Title II, it would be all state and local governments and all departments, agencies, special purpose districts, and other instrumentalities of the state or local government. Anyone who has programs, services, activities, anything that we invite the public to. It would also include any contractors that you use. That you would want to make sure that they follow any Title II guidelines, that they're all there. So examples of that would be, let's say you had a nonprofit group that actually conducted drug treatment programs for your city or your state, or maybe a convenience store that sold state lottery tickets. I don't know if Utah has a state lottery ticket, but you get the idea. So some real basic principles. I don't know what happened there, but there were some real basic principles when it comes to the ADA as a whole. The ADA really focuses on equal treatment as a fundamental purpose of the ADA. Okay? People with disabilities must not be treated in a different or inferior manner. So, give you an example, let's say a public health clinic could not ask a person with a mental illness to come in after all the other patients have been seen because they fear that that person might cause an outburst or that their behavior may be disruptive to the group. Or let's say a county parks and recreation department could not require people who are blind to have a companion with them when they're hiking on public trails. Bottom line is, if it's open to the public, it's open to those with disabilities. The integration of people with disabilities into the mainstream of America is a fundamental purpose of the ADA. So we always think about all the thou shalts and the thou shalt nots when it comes to these kind of laws, but the spirit behind the ADA was just about bringing people into the mainstream of American life. And the reason that's important is that historically, a lot of entities, a lot of public entities have created separate services for those with a disability. Now, the ADA doesn't say you can't have let's say a swim program that is specifically focused for those who have a mobility disability. But it does say that you cannot require that a person with a mobility disability attend that class only. If they would rather attend the swim class that's open for everybody, well, then they should attend the swim class that's open to everybody. I don't know what happened here. There we go. Other basic principles would be people with disabilities must meet essential eligibility requirements for public entities, and they cannot use requirements to screen out people with disabilities. So to kind of give you an example, let's say that to enter the public building, I have to show you a driver's license. Well, a driver's license would be a way to screen out somebody with a disability, because if I'm blind, maybe I don't have a driver's license. Now, asking for ID is one thing, and that's perfectly fine, but doing things that intentionally screen out those with disabilities, not so much. Another important thing that you might want to know is that rules that are necessary for the safe operation of a program, service, or activity are allowed, but must be based on current assessments of the actual risk, not an assumption. Okay? Basically, even if you have a disability, you don't get any special treatment because of the disability. If there is a safety issue involved, well, it's just the way it is. Let's kind of give you an example of, let's say there was a prerequisite for a board member who actually approves building plans and things like that. If the prerequisite is that you have some architectural background, well, it wouldn't matter if I have a disability, I still have to meet those requisites, because if I don't have it, I could be risking somebody's life. All right, let's dive into Title II. Now we've kind of covered some real basics of the ADA. Title II talks about reasonable modifications. Okay? Many entities have basic policies, practices, procedures that are adopted without thinking about how that will affect people with disabilities. Now, even sometimes neutral policies, or those that seem neutral, can make it difficult or impossible for a person with a disability to participate. In these cases, the ADA requires that public entities make reasonable modifications to the usual way of doing things to accommodate those with a disability. So let's say that part of the policy for paying a parking ticket is that you have to wait in this line, and that you wait in the line until you get to the front, and then you pay your ticket and you are on your way. But a person with crutches, okay, maybe somebody that has difficulty waiting in a long line. Well, first off, they're not required to be moved to the front of the line. That would be kind of special treatment. But a reasonable modification to that policy of you got to wait in this long line, maybe we ought to provide them with a chair, and we don't let them, or we don't have them lose their place in line. So when their spot comes up, now they can move to the front. They still had to wait the same and appropriate amount of time, but you get the idea. Okay, another modification that we would think about would be things like a lot of cities, states have no animal policies in certain areas. Well, if it was a service animal, we might have to make a modification to that policy to allow the service animal. Maybe another example would be a building where there's no food allowed. Okay, and in those particular instances, we might allow a person who has diabetes to bring snacks or small meals with them so that they can control their glucose levels. I will say, though, only reasonable modifications are required. It is not always possible to accommodate a person with disability at all times. Okay? So, for example, let's say that the museum gift shop only has one person that actually works in that gift shop during a given shift. It would not be a requirement to pull that person and essentially ask them to be a personal shopper for a person with disability during that time, because it would leave the rest of the gift shop unattended. Okay. All right, so we opened the door already, and I'm going to go ahead and jump in on it. In service animals. This one, I debated whether I wanted to open this topic or not, but it is a reasonable modification. So I want to talk about it briefly. Typically, service animals in itself is at least a 2-hour class with a lot of frustrations along the way. But I will tell you that when it comes to a service animal, the ADA has very strict definition. A service animal is any dog, and that's a key word, that is individually trained to do work or provide tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. Now, there are some provisions for miniature horses, but those are very few and far between, and we're not talking about them today. So we're just going to kind of move on with that one. All right, so just a couple things real quick here. Under the ADA, now keep in mind there are other laws that may come into play here, but under the ADA, which is what I know, comfort, therapy, and emotional support animals do not qualify. They have not been trained to do a specific task related to a person's disability. Okay? Service animals must be allowed in all areas where the public would go. Public entities may only exclude service animals if the dog is out of control of the handler and the handler cannot or does not regain control, or if the service animal is not housebroken. Now, back up just a little bit, I do want to kind of point out, when it comes to out of control, just because a dog barks once, well, you know what? They're dogs. That's what they do from time to time. If they're barking uncontrollably, that's a whole other issue. If they're growling, snarling, threatening people, that's out of control. If they're running around knocking things over, that's out of control. But that doesn't mean that just because they make a small whimper, oh, they're out of control, and we throw them out of here. Okay? We also want to make sure that we understand that a service animal out of control or not housebroken can be asked to be removed, but never the person. So you're not excluding the person or the handler. You're excluding the animal. Another thing would just be when it comes to legitimate safety concerns, you do have the right to refuse a service animal into that particular area. And again, these would be very case-by-case specific. But let's say a local burn unit at a hospital. Okay, we may not allow a service animal into there because it's a sterile environment. Or maybe there is a special exhibit at a zoo, and in that zoo exhibit, the animals on display are the prey, or the natural prey of a dog. Okay, in those particular issues, you could possibly make the case to say we're going to exclude service animals here. A couple other things real quick here. Public entities may not require documentation or proof that an animal is certified, trained, or licensed. There is no such thing. So if you're requiring it, I guarantee you that whoever's presenting it to you made it up. And there's plenty of ways we can print a document that says, here's a certification for this animal. There are no certifications or licenses for service animals. They don't exist, and the DOJ is very adamant that they are not going to require them. And will they in the future? I don't know, but it's not something that they want to do now. When it is not apparent, the public entity can only ask 2 questions about service animals. Okay? Is the animal required because of a disability, or is this a service animal? And what work or task has the animal been trained to do? A lot of cases you get the animal, or they get the response of, yes, it's a service animal, I have PTSD. Okay? The question would always come down, what has the animal been trained to do? And I'm not here to get into a debate on whether or not that should or shouldn't be, but the bottom line is these are the questions that a public entity can ask, or a government entity can ask. You can never ask about the nature or an extent of an individual's disability. And this is where it goes wrong a lot of times. A frontline employee asks the question, is this a service animal, and what has it been trained to do? And the person's response is, yes, it's a service animal, and it helps to, or it picks things up if I drop them. Oh, do you have a back problem? Well, now we've asked too many questions, and you've gone too far, because you're starting to ask me about the nature and extent of my disability. You get the idea. Very last, when it comes to service animal, I do want to point out that the ADA does not restrict the breeds of dogs that may be used as service animals, and that a public entities do have the right to determine on a case-by-case basis whether the use of a particular service animal poses a threat. Okay? The reason I bring this up is because a lot of areas have bans on certain breeds. Let's say I know for a fact that the city of Denver has a ban on pit bulls, and that's great. That's what they decided they wanted to do, but I can tell you that when it comes to a service animal, the service animal still has to be allowed. They are not banned because they are a pit bull. You can individually, if you had knowledge that a specific animal caused a problem, let's say you knew, for example, that my service animal attacked and mauled a child, well, you can ban that particular service animal, but you cannot make a broad stroke and say, well, you know, his animal was a Cocker Spaniel, so all Cocker Spaniels have been banned from the city. Okay? Do you want me to pause here, Jason? Or do you want me to just keep rolling?
I think we're doing pretty well. I haven't seen questions come in. Just remind people that that you can type your questions into the chat box or the Q&A box, and we'll get those to Chris as we go along. So yeah, I think we're good to go. I don't see any questions so far. You covered it so well. No questions.
Yeah, exactly.
That's impressive with that subject too, because that's a challenging area.
And we will have some time at the end, hopefully, to answer any questions that you may have. But we're going to keep going because there's a lot more to cover. Again, Title II covers another huge section of Title II is all about communication. And do have to understand communication is an essential part of providing services to the public. And I don't care if you're a state and local government or if you're Kohl's department store. If you're going to provide services to the public, you probably have communication in mind. The ADA requires public entities to take steps to communicate effectively with people who have disabilities. The ADA uses that term of steps that you need to take. They call it auxiliary aids and services, and they use that to describe the possible resources needed to provide this effective communication. All right, so what are effective aids and services? Well, it could be almost anything. It could be anything from screen readers to Braille. It could be CART services, closed captioning, open captioning, text, video phones, sign language interpreters. This is, again, not an exhaustive list. This is just what I could fit on the PowerPoint. Okay? The term auxiliary aids and services really just comes down to what is it going to take to communicate with somebody who has a disability. Okay? Now, obviously, there's a lot of different types of disabilities, and there are a lot of different types of auxiliary aids and services. So the nature of the communications differ from program to program, so the ADA is actually very flexible. But when you are thinking about which auxiliary aid or service do I need to use, you always want to look at the nature of the communication, the length of the communication, and the complexity of the communication. So a person who is deaf may only need to exchange notes if you were, let's say, wanting to pay that parking ticket. Real quick interactions back and forth, no problem. Now, a person who is deaf attending a town hall meeting, well, they may require a qualified sign language interpreter or CART services. Who knows? A short, straightforward document, let's say it was a quick document on how to get a hunting license. Okay? That might just be something that can be read to a person who is blind. But if I was giving somebody a copy of, say, an emergency preparedness plan, that's not something that I'm going to want to sit and read to them, nor am I going to expect them to sit and listen to it for the entire length of time. So I may be having to provide them with an accessible or electronic document that they can use at their leisure. Now, public entities are required to give primary consideration to the type of auxiliary aid or service requested by the person with a disability. The bottom line is, guys, they know better what they need than you do. Okay, so if you try to make a blanket and say this is what we're going to use because this is our most cost effective, well, it may not be the most effective for somebody else. But there are times when you don't have to actually give them what they want. And I think this is wrong. I think I should have said unless you can demonstrate that another equally effective means of communication is available. And again, it's just kind of it's up to you to prove it. Unless the requested aid or service would fundamentally alter the nature of the program, service, or activity. And I'm not going to get into too much right now about what it would take to fundamentally alter a program, but yeah. Unless the requested aid or service would create an undue hardship. But I will say this, so we just brought up the idea of a fundamental alteration and the idea of an undue hardship. But if you are going to use undue hardship and fundamental alteration, you need to make sure that that decision that a particular aid or service is an undue hardship, fundamental alteration, that has to be made by a high-level official. And usually it's nobody or no lower than the department head. Why do we say that? Because we don't want somebody who has no idea of the budget, no input when it comes to how money is spent, making the decision to say, no, I'm not going to do that because it's much too expensive. What? A sign language interpreter is how much money per hour? No, we can't afford that. So we would never leave that decision to somebody who's less than a department head. Now, a public entity services, programs, or activity, when viewed in their entirety, must be readily accessible to use by people with disabilities. So we're starting to talk now about program accessibility. We're done with communication for the moment. Sorry, that's the highest level I can give you. But so what is a program, service, or activity? Again, it is anything that you invite the public to participate in. It could be anything from hunting licenses, maybe art exhibits. It could be your museums, voting. That's a huge one coming up here real soon. Sporting, job postings, fairs, festivals, you name it. Anything that you invite the public to is a program, service, or activity. Public entities have an ongoing obligation to ensure that individuals with disabilities are not excluded from program services or activities. because facilities are unusable or inaccessible to them. Inaccessible? Let's try that. Now, that's not to say that all of your facilities have to be made accessible, but when we look at how do we get our programs accessible, our first option or our first thing that we might consider would be making structural changes to the facility itself just to allow people to get in. Okay? The other thing that we could consider would be the program, service, or activity could be relocated to an accessible facility. Or the program, service, or activity can be provided in an alternative manner. Okay, so I'll give you a couple examples of an alternative manner. Let's say that a local elementary school without an elevator to a second floor, well, the teacher could be relocated maybe to the first level, to a first floor if they had a student who had a mobility disability. Okay? Maybe a public library that is not accessible could provide curbside service for patrons with a mobility disability. Just a couple ideas, couple examples. I do want to point out, though, many services are available only online. So web-based services and programs must also be accessible. And again, getting into all the specifics on that one would take forever, but this was a recent example. We had a state and local government that we were working with, and we had worked very, very diligently with them. Their website that they believed was very accessible, and for the most part it was, until you got to their documents. So there was quite a confusion at one point when a person said, but there is no information on your website. A blind user said, there is no information on your website about how to obtain a particular license. The problem was it was on a PDF file. So to a screen reader, that was nothing more than a picture, and that's all it said, picture. It didn't give them any information. It didn't tell them anything that they needed to know. And so they realized that all the PDFs that they had on their website were really not accessible. All right, so we talked about structural changes, and we're just going to hit some real key points when it comes to structural changes. Okay, structural changes are not required where other solutions are feasible. Okay, however, if other solutions are not feasible, structural changes are required. Structural changes must meet the requirements of the 2010 ADA standards, unless it's technically infeasible to do so. I know I keep throwing a lot of, yeah. When compliance is not technically feasible, the changes must follow the 2010 standards to the maximum extent possible. And I bring that up just because bottom line is we don't want to say, well, you know what, it wasn't possible to meet the 2010 standards, so we just didn't do anything, or we just changed it altogether. No, that's not the way it works. Okay? However, deviations from the standards must not pose a significant safety risk. So you have the ability, let's say you couldn't put a ramp in that met the standards. It had to be 3 degrees steeper than what the standard said it should be. And that's great. But I've been around town and I have seen those ramps that are basically death to a person who might be in a wheelchair. Because I know if they tried to go down that thing, they're going to be in a world of hurt. They're just too steep. Okay, that would be a safety risk. And even the deviation that you have can't impose a safety risk. All right. Oh, I will point out, though, that public entities are not required to take action that would threaten or destroy historic property. Okay? Now, I'm sure that there's somebody somewhere that said, hey, you know what, let's move all of our program services and all that to historic properties, and that way we don't have to worry about anything. That's great, but you still have an obligation to provide the service, program, or activity in an accessible way. Okay? We might look at things like, let's say there was an office building where a public service met with individuals in a private office and said, you know, had a counseling session with them, whatever. So to make it accessible, they're going to meet down in the lobby. Well, that's great, but we want to consider the fact that were they meeting in a private office because the conversations they had were private? And if that's the case, moving it to the lobby is not keeping it private, and therefore we're not providing treatment. All right, structural changes some more, getting off topic here. Entities are not required to take any action that would result in an undue financial and administrative burden. Again, no one lower than the department head should ever make the decision that something is an undue hardship or a financial burden. It should always be somebody who has budgetary authority and responsibility for making spending decisions. Okay? Again, that is just huge. I can't tell you how much we hear that from time to time. And regardless of whether it is a financial burden or not, the entity still needs to make sure that individuals with disabilities receive the benefits or services provided to everyone else. All right, kind of mentioned real quick, it's in its entirety, and I wanted to hit this one very fast, but not all facilities are necessarily need to be made accessible. I know that sounds odd, but the ADA does recognize the fact that there's budget constraints. There's, financial resources that have to be considered and time. Okay? But if we cannot make all of the facilities accessible, we need to look at some specific information. Things like the geographic distribution of sites, the availability of public transportation, hours of operation, and the programs offered at each site. So I'll give you kind of a quick example. Let's say we had a multiple public swimming pools, okay? And in all those public swimming pools need to be made accessible. But again, because of financial constraints, because of time constraints, we cannot just wave a magic wand and make them all happen overnight. That's fine. But we would start to look at which of those pools can we make accessible, and then we want to consider in that which of the programs that we're offering in there, those type of things. I want to point out also that you have an ongoing obligation to make sure that all services, programs, activities are provided in an accessible way. And again, ongoing is the key word. So not all improvements to make program services and activities can be completed in a single year. Everybody's pretty much aware of that. Improvements are allowed to be spread out over time. And again, the ADA understands, or I should say the Department of Justice understands, that rising and falling revenues can affect things. So what may have been on the budget for this year may not be on the budget for next year because of decreased revenues. But it may also be something where what wasn't going to be on next year should be moved because of increased revenue. And I also want to point out that when it comes to what the priorities are for making things accessible, we should always consult with people who have disabilities before you set those priorities. So you might think that it's the most important thing to get this library accessible versus this pool. But when we talk to those with disabilities, we find out that it's not either of those, that it is the courthouse. I don't know what the answer is there, but bottom line is consult with those who use the services. All right, my favorite topic in the whole wide world, the 2010 standards for accessible design. And it's my favorite today because I don't have to cover it all for you. I'm going to give you a couple highlights when it comes to 2010 standards, but I am not going to get into any details. I do want to point out that there are no grandfather clauses in the ADA. So if somebody tries to tell you, you're talking to your architect and your architect, that's grandfather. Well, there is no such thing as a grandfather clause in the ADA. There is something called safe harbor. Now, bottom line is, if you had a facility that met the 1991 standards back in March 15th of 2012, it might be in safe harbor, okay? And the key word being might be in safe harbor. I will tell you that safe harbor is applied on an element-by-element basis, and it remains in effect until the entity decides to alter the facility. And there's where we get into the triggers. Most things don't stay the same. So a building that was compliant and met the standards, 1991 standards back in March 15th of 2012, but then somebody decides that they want to change the flooring. They've got to replace the carpeting. They've got to replace what you have now triggered an update to everything else that goes along with that particular element or room. And again, I can't get into all the specifics on it, but do know that anytime you alter something, you're triggering compliance with 2010 standards, not just the 1991 standards. I'll give you a quick example would just be, so your parking lot meets 1991 standards, it's striped appropriately, all that great stuff, but somebody decides that we're going to restripe the parking lot because it's getting faded. And well, the moment we did that, we decided that we were going to comply with 2010 standards, and now we need to make sure that we have the correct number of van accessible parking spaces. Okay. When it comes to the 2010 standards for accessible design, know that it covers a lot of areas. Okay. And there are some areas, though, that are new to the 2010 standards and are not eligible for safe harbor. Since you couldn't have been compliant before in 1991, you couldn't have been because it wasn't covered. Well, now if you have them, they have to be up to date immediately. All right, so if you have miniature golf courses, if you have vending machines, if you have exercise equipment, residential facilities that fall into this narrow category, all of those would now have to meet 2010 standards. Do know that the 2010 standards have to be used in all construction and alterations. Boy, having a hard time there. And it covers a host of different elements. I mean, it is just, it's huge. So here's just a few. All right. Whew, kind of coming into the end here, but one of the biggest parts of Title II. Title II outlines some administrative responsibilities. Now, if you have 50 or more employees, it is required that the entity designate at least one employee to be responsible to meet ADA compliance. This is considered to be an ADA coordinator. ADA doesn't actually use the term ADA coordinator. It just says, hey, you got to designate somebody to be your ADA liaison, essentially. Just take care of all the ADA issues. I will tell you that the Department of Justice has determined that an ADA coordinator should be responsible for coordinating the efforts of the government. The ADA coordinator should investigate any complaints, and that the name and address or contact information, let's just leave it at that, name and contact information of the ADA coordinator must be provided to interested persons. I can't tell you how many times in trainings we say, you know what, I'm going to give you guys 10 minutes. I want you to use any means necessary to see if you can find the ADA coordinator for, I don't know, let's just pick on Lufkin, Texas. And I can't tell you how many times they fail. Partly because that information is just not public. Why do you want it to be public? Well, obviously, if you have that as public information, I can get to somebody who can actually resolve my concerns. And how do we make that public? Well, there's a lot of different ways that we can make that public. I'm not going to get into what it takes to be an effective coordinator, but I will tell you that bottom line is, I would say have it on your website. You can choose how you want. I'm not here to dictate policy, but I will tell you that if I want to know anything about Beaver County, Utah, the first thing I do is I'm going to Google it. And I'm going to find the official site for Beaver County, or I'm going to pull it up. Now, if I've got a question on how to file a complaint, I'm going to look on the website. If I can't find it, I'm going to go somewhere else, specifically probably the Department of Justice. All right, moving on. Title II also outlines another part of this, which is you have to adopt a policy of non-discrimination. Now, earlier we said if you had 50 or more employees, not now, okay? This is for everybody, regardless of the size of the entity. Everyone should have a policy of non-discrimination, and it should be public, okay? The ADA notice requirements, this is for everyone. It's not just for those who have 50 or more employees. This is just an example of what a policy, non-discrimination policy might look like, but it should basically just have some statements about your employment policies, your effective communication policies, how to ask for a reasonable modification, or how would I go about requesting an auxiliary aid or service, and how to file a complaint if need be. Again, the ADA describes and says that this should be public. So what do they mean by public? Well, initially, when the ADA first passed, we didn't really use the web as much as we do right now. So they talked about things like putting it in newspapers and running radio advertisements. But the website is probably one of the key things that we can do. Just having it on our website will help us out immensely. Oh yeah, and you do want to make sure that your notice is available in various formats, because again, we want to provide effective communication. All right, the other thing would be establishing a grievance procedure and making it public. We've talked about, how do I file a complaint? Well, if I'm going to file a complaint, I need to have an actual procedure that shows me what to do. Bottom line is, we want to make sure that we have a description of how and where a complainant can file a complaint with the entity, a statement notifying potential complainants that alternative means of filing will be available. So again, let's say you only have it in a written format, well, you might need to provide it in electronic format as well. Okay? A description of the time frames. So give me an idea of how long this is going to take. What do I need to do if I don't like your opinion? Is there an appeal process? And a statement of how long you will retain their complaints. From there, the Title II describes what we call a self-evaluation. Okay? And bottom line for a self-evaluation is to simply look at your world from all angles and write down what you find. You want to look at things like the physical barriers that you find, the communication issues that you might find, your emergency management procedures. Do they include those with disabilities? All of your web-based services, your hiring practices, your training. How do you train your staff and staff members when it comes to disability etiquette, disability awareness, things of that nature? Give you an idea of a couple key policies that you absolutely should positively have in place. Things like mobility, other power-driven mobility device policies, service animal policies, ticketing policies, all of these should be covered. And then you want to document what you find. Again, what location, what policy have you reviewed? What about the location, policy, and procedures are you assessing? What was the requirement under the ADA and other similar laws? Your findings on how they compare with the requirements and the recommended action. Okay? Again, this is your self-evaluation. This is where you find out what's going on. Now, what I do want to point out here is in a true self-evaluation, you are not just looking at what's wrong, you are looking at everything. If the doorway doesn't comply, that's great, but if the doorway does comply with 2010 standards, you still want to list it that I looked at it, it met, here's why. Okay. That's kind of the self-evaluation, but it starts moving into the transition plan. The transition plan is where you put your findings into action. Now, the Department of Justice describes the transition plan as a living, breathing document. What they don't want to see is a transition plan that is rusting or sitting up on a shelf gathering dust. They want to see something that is moving, that is always being looked at, that is always being updated. So in the transition plan, you want to list what findings were compliant, as we did before, findings that were addressed prior to the publication of the transition plan. So even if you addressed it back in 2014 or 2012, that's great. You want credit for it. Okay? All findings that required change listed by priority, and again, this is where we enlist the help of other people to determine what our priorities are, and timelines for the changes to go into effect. You also want to have who's responsible and how are you going to continue to follow up on this. All right, take a deep breath, because that was Title II in the biggest nutshell.
That was awesome.
I can breathe and cough now.
Yeah.
A couple things that I do want to point out is that it's very important for you to stay up to date. A couple things that you can do. We do have a newsletter that is fantastic. Kind of keeps you up to date on all of the most current ADA information and all the stuff and happenings and all the good going on. Feel free to sign up for the newsletter. We also have an ADA Coordinator mini camp coming up in Salt Lake City, Utah, September 20th and 21st. Again, you can check out our website if you want more information on that. But now I will open it up to any questions, and there's our contact information, so you can jot that down. Phew.
Awesome. That was. I know we really pushed it because we like to keep these webinars in digestible bites, so people can get the information. But you did a great job to give us a good overview with a lot of clarity. I know there are a lot of questions, and folks, if you've got questions, type those in the Q&A box or the chat box, and we'll dive into those right now. But I thought that was the most concise explanation that I've seen ever for that. Just along those lines, though, as far as this is a primer, this is an overview. We will be doing 2 other sessions on this same subject on July 21st and September 15th that we have scheduled, and in those we'll be talking about physical facilities. The other is talking about employment and accommodation in employment. So we'll take those a piece at a time. So then we have just a manageable amount of material to go through during that time. Just remind everybody to put your questions here. It looks like they're coming in quickly. I had a couple that I wanted to hit quickly, and we'll dive into these other questions. Chris, Title II, difference between just a real overview, difference between public and private. Is that enough information for you?
Title II is, again, public entities. So public entities being state and local governments, okay, and anything that they do, from anything from the Park and Rec Department up to the city courthouse or the county courthouse. Title III covers private entities, and that can be anything from the mom and pop organization to Walmart to Kohl's department store, those that are for profit, essentially. I guess that's kind of the easiest way for me to explain it. But
okay.
Very similar information on both sides. There are some differences. All are covered under Title I, which is employment, which I think you'll find out about next time. But again, specifically, Title II, state and local governments, very specific on what needs to be offered.
Okay, great. Maybe is there a chance that you could go back over the 50 or more employees requirement? What falls under that, and if you have fewer than 50 employees, are you out of the woods?
If you have fewer than 50 employees, again, no, you're not out of the woods. You don't necessarily have to have an ADA coordinator. But do keep in mind, when we say 50 or more employees, that includes part-timers, okay? So if you've got 50 or more people on your payroll altogether, then you have 50 or more employees. And does that make any sense, or does that answer the question? Okay.
Yeah, absolutely. Here's a question. Registration fees for service dogs are not considered impermissible charges under the ADA. Is that correct? So a dog license fee, I believe, is what we're asking.
Dog license fees as a whole, no, not a problem. You are allowed to have dog license fees because they're still animals, and they still need to meet, state and local safety codes, things like that. So yes, having a dog licensing fee is not a problem, but you cannot assess any additional fees. And I do want to point out that a lot of entities will actually go above and beyond. So there's nothing that says you can't go above and beyond the requirements of the ADA. I know a lot of state, local governments have, there's no charge for service animals. So when you present, you can get the license and it's no charge. And that's great, but it's not a requirement. So yes, you are allowed to have a standard licensing fee for all animals.
Okay.
Could we just maybe clarify one other thing on the 50 employees? Now, is that 50 employees at any time during the year? So, during the winter, I've got 30 employees, but in the summertime, I hire a bunch of seasonal employees, and so I might have 60 employees during the summer.
Seasonal employees do count as well. Yes, so it's basically, we'd look, if you were getting down to the nitty-gritty and you were really trying to make the case to say, I do or don't need, I can tell you if the Department of Justice showed up, they would look at your payroll for the last year. How many people were on your payroll?
Okay.
Okay. Next question we have, Lisa asks, can you give us more information about how to make our websites accessible?
That in itself is a huge class, and it is very difficult. I mean, I will tell you just some basics, okay? Very basic things that you want to make sure that you do have. If you have videos on your websites, make sure that they are captioned. Okay, either open or closed caption, doesn't matter. Do make sure that any pictures that you have on your website are properly alt tagged, that any information is actually readable by a screen reader. The biggest thing I can tell you, and this is what I do when I'm developing online training courses, download JAWS screen reader trial, okay? JAWS, J-A-W-S. And if you download JAWS as a free trial, it will allow you to run JAWS, which is a screen reader program, in 40-minute mode. And you can do this almost indefinitely. But it will only allow you to run it for 40 minutes at a time. But it will allow you to go onto your website and hear what a person who is blind hears when they log onto your website. You will be shocked and amazed. We did this for a very large amusement park, and when their developers heard what their website sounded like to a blind user, they were shocked. They were appalled. It's scary sometimes because there's so much information coming at the blind user that is superfluous. It doesn't need to be there. For example, if a picture is not properly alt tagged, it reads as image. But if you have 22 images in a row, it says image, 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 and that's not fun. Okay? I really, there's so much when it comes to websites that it would be hard for me to get into it in a very, very short time. I can tell you that it's something that is covered just a touch more in depth at the ADA coordinator. But again, feel free to contact us if you have any questions. We would be more than happy to do it in one-off situations.
Great. Let's see, there's a question, so can we print those templates off of the Trust Web? You have some templates there. Are you willing to share those, and we can distribute those out to everybody who signed up for the webinar?
The PowerPoint templates? Is that?
I believe that's what they're asking. Maybe Michael, if you could give us some detail there, exactly what you're looking for.
If you were looking for the PowerPoints, fantastic. Be my guest. Download them all you'd like. No problems.
Okay. Here's another question here, in case Michael wants to respond there. When hosting a city event, are we required to have someone that can provide sign language?
Again, without knowing the actual city event, Maggie's giving me it depends. The most important sign language I've ever learned is it depends.
It depends.
Again, we'd have to know the specific type of event that you were having. Were you doing something where you're addressing the public, in which case, yes, a sign language interpreter might be required, but it might also be something where cart services could be effective. You'd really have to look at all the different situations. And then when it comes to the ADA, that's the overview that I gave you, but there's so many one-offs that can be done different ways. Does that answer the question? I think basically the answer was it depends, but I'm leaning towards probably yes.
Yeah, I imagine that one's for sure a depends, because an activity could be a lot of different things.
And that would be something, again, Maggie kind of pointed it out. It would be on request in that particular case. You know, it might be something where a person with disability reaches out and says, hey, I'm going to be attending this event. I would like a sign language interpreter. But if you knew that you were addressing 1,000 people during a big, I don't know, what I can't even think, award ceremony at the festival, you might have to think, out of 1,000 people, there's probably a good chance somebody out there has a disability.
So, follow-up question on that. So, would it behoove any of these local governments out there to have a list of people that could provide some of those services?
I probably wouldn't have a list,
Okay.
but I would make it public. So when I'm advertising my fair, my festival, my whatever, at the bottom of the little advertisement, I would just simply say, for accommodations, call this number or contact this website, those type of things, so that if somebody wants to reach out and say, yeah, I'm going to be there in attendance, but I am going to need, you will know it in advance, and you can really make the case that I've done everything I can to make myself accessible to you.
Yeah, I guess my question though was, should an entity have a list of interpreters or people that can provide those services?
Sorry, I heard list and I was like, no, we got to cut you off right there.
Yeah, I agree.
But a list of services, yes, absolutely. It would very much behoove you to know who you need to call and when you need to call them. It's also, again, and we get into this in a lot more depth when it comes to communication in other classes. A big part of communication, there's things like VRI, which is a video remote service type thing where maybe I just have an iPad with an interpreter, and if I can meet the bandwidth requirements and all the good stuff there, it provides me a very fast ability to bring an interpreter in. Not going to apply to all situations, and it's not going to work in all situations. But the biggest problem is, do my frontline employees know how to operate it? Or do they now have to call their manager to come over? And what we end up having is this 1 hour delay for this person who is deaf to actually participate in what needs to go on. Whenever you use services, whether it be to contact a sign language interpreter or whether it be VRI or any service whatsoever, it is imperative that our frontline employees know how to use it and that it can be set up quickly. Okay. So yes, having lists would be great.
Great. Had another question. The dates on the webinars, we have those scheduled for July 21st and September 15th, and we will send out a notice on those. Generally, we try to do on these. We try to do it with a little more notice. This one here, we only gave you about 10 days notice on this, but we will send that out ahead of time. If you're not on our distribution list for training notices, send me an email. That's at jason@utahtrust.gov, jason@utahtrust.gov, and we'll get you on our distribution list so you get notices for those. Okay, well, I think that's all the questions we have here. Any final words?
Just, again, did we drink from the water hose today? There's so much information, but do know that we are always here to answer questions. So contact us anytime. On our website, there's a very convenient little ask a question button where you can do it electronically, so you don't even have to get tied down at the moment. We'll respond to you electronically, however you prefer. Call us, call any of the ADA centers. This is what we do. We help people work with the ADA and being compliant as much as we can.
Awesome. Thanks.
Thank you, and I appreciate your time.
Chris. Great.
Thanks, everyone.
And we appreciate Maggie being in the background as well.
Yeah. Giving me the approval if I'm like,
It's a challenging subject, and hopefully everybody's got some clarity. I know it helped me out on a number of things, and so we'll continue this with those upcoming webinars, and we appreciate Chris and his preparation for that. Everybody go out and have a great day. We'll talk to you soon.
Thanks, everyone.